Okay, thanks, Yarrow. And thank you to Patricia and Beverly. I'm hoping everyone can hear me. I think I'm unmuted. Okay. Um, Thank you to everyone at Advocates for Children of New Jersey for having me here today. I greatly appreciate the opportunity to be on the line, and truly what an incredible turnout. Quite impressive. I think that's clearly a testament to the great work that you're doing. I am Amy Vazquez, the Director of Legal Content for the Employers Association of New Jersey. In case you're not familiar with EANJ, we are a nonprofit membership organization comprised of employers located throughout New Jersey. And our mission is to help good employers be better. And we do this in a number of ways through training, education, seminars, webinars. We come out and do in-house training, although that's sort of all moved virtually, over these last few months, and also through informed discussions. So our members have direct and unlimited access to our professional staff. And while we don't provide legal advice, and nothing I say today should be construed as legal advice, we do provide members with information so that they're able to make informed decisions when it comes to their workforces. We help explain various aspects of federal and New Jersey employment law, and point out where there might be risk in taking one course of action over another. Typically, the questions that we receive cover all aspects of the employment relationship, from hiring to separation and everything that falls in between. We'll take a lot of calls on things like wage and hour issues, leave administration, mandated benefits, because New Jersey has a lot of them, COBRA, ACA, discrimination and harassment, just to sort of rattle off a few for you. Needless to say, these past few months have been quite intense for employers and, for everyone, but also for employers. And a lot has happened in a very short period of time. So many of the calls that we have been fielding at EANJ have had to do with how to handle furloughs, how to handle layoffs. We've been getting questions on how unemployment works in general, how partial unemployment works. While unemployment is ultimately between the claimant and the state, employers in many cases, and especially now, have been looking to help guide their employees in the right direction and provide them with accurate and helpful information so that employees can successfully file their claims and begin collecting as soon as possible. So now, we're beginning to shift gears. We're moving into stage 2 of the governor's reopening plan. And while I understand that some child care centers have been operating for emergency child care purposes throughout the stay-at-home period, come June 15th, you're going to have the green light to begin operations again, albeit with increased safety precautions and protocols in place and reduced capacity from what I've read. Of course, you're going to have industry-specific guidelines to implement to protect your workers and the children and the families that you serve, as well as, the general CDC guidance. So I think what I'm saying is that there's a lot of information to digest in a relatively short period of time. So my hope in the time that I have with you this morning, or this afternoon, I should say, is to provide you with some guidance on some of these issues, really focusing in on the unemployment and some of the return to work issues so that you can make informed decisions and carefully plan for your reopenings and beyond. If you can go to the next slide, please. So Yarrow went in detail through the provisions of the FFCRA. That was the first enormous piece of federal legislation that employers had to digest back in March, and that took effect on April 1st. The second piece of enormous federal legislation is the Coronavirus Relief and Economic Securities Act. It's otherwise known as the CARES Act. This law is, again, enormous. There's a number of components to it, including the Payroll Protection Program. Some of you may have applied for those PPP loans. That's all part of the CARES Act. But for our purposes today, we're really going to just focus in on the expanded unemployment provisions. And there are 3 separate programs that make expanded benefits available. So the first is the Pandemic Unemployment Assistance, the PUA. This expands eligibility for individuals who are typically not eligible for benefits. So this is going to include your independent contractors, self-employed individuals, for this whole laundry list of COVID-related reasons, which I'll show you when we move on to the next slide. But the second program, the column here in the middle, is the federal pandemic unemployment compensation. So this program provides for the additional $600 per week to anyone who is collecting benefits. This is the one that has been getting all of the headlines. I'm sure you've heard about this. We've had a lot of questions from our members regarding these additional $600 payments. In New Jersey, unemployment is, the formula to calculate unemployment is 60% of the claimant's average weekly wage, and that maxes out at $713 per week in 2020. These $600 payments provided for under this new legislation are in addition to the employee's weekly benefit rate. So in some cases, an employee may end up collecting more money on unemployment than they would have had they actually been at work. And I know that's a tough pill for employers to swallow, especially as you're trying to get people to come back to work. Claimants don't have to do anything to claim this extra money. They simply file their initial claim, they certify their benefits each week, and then the state takes care of the rest. From what I understand, the payments come as separate deposits from the employee's regular weekly benefit rate. And the $600 stimulus payments are available to everyone who is determined to be eligible for unemployment. So this is going to include those who are on partial unemployment, for example, because their hours are cut. If they're determined to be eligible for $1 of unemployment, they will get the additional $600. And the third program here on this slide is the Pandemic Emergency Unemployment Compensation. This provides for an additional 13 weeks of benefits. So instead of the traditional 26 weeks of unemployment is usually limited to 26 weeks. This extension will allow claimants to collect for a total of 39 weeks. So this is sort of a high-level overview of the program. Or programs, I should say, but I also wanted to give you a snapshot of the expanded unemployment reasons under the PUA, because I think that they may have some impact on you. So if you could go to the next slide, please. So a New Jersey worker who is experiencing any of the listed COVID-19 scenarios could be eligible for pandemic unemployment assistance. I'm not going to read through all of these. They're here for your reference. But you can see the PUA is going to be available to someone who's been diagnosed with COVID, or someone who needs to care for a family member who has been diagnosed with COVID. Now, here in New Jersey, as Yarrow, took us through, we already have programs in place that would have covered these issues, even without this new legislation, right? We have mandatory temporary disability benefits. We have family leave insurance benefits. And as I've been talking with members on a daily basis, one of the things that we've all been struggling with is wrapping our minds around the fact that unemployment is now available for these reasons. So I think it's sort of important for you to keep in mind that New Jersey is only one of a handful of states that has temporary disability and has family leave insurance. I think we're maybe one of like 6 states that have that. So the vast majority of the company don't have protections in place for that. And the CARES Act, of course, is a federal program, and every state has unemployment. So I think in terms of implementation, it just made the most sense on a national level to make this assistance benefit available uniformly using each state's unemployment system. How does an employee know which benefit to apply for and when? That's a very good question. The New Jersey Department of Labor's website does clearly indicate that a worker should not apply for any state benefits, whether it's disability, family leave insurance, or unemployment, if they continue to be paid by their employer during COVID-19. So if you are paying out FFCRA monies, that emergency federal sick leave that Yarrow described, for example, that employee should not be applying for unemployment. I think that many employees are confused to what they're entitled to. I know employers are confused because I talk to them every day. So if the employer is confused, very good chance employees are confused. And on a practical level, people hear about this additional $600 per week, and it's very attractive to them. Even if it is only a short-term gain. Next slide, please. So I did want to talk a bit about partial unemployment because it's tricky and it involves math. And I hate math, but I will do my best to try to break it down for you. So first up is eligibility. To be eligible for partial unemployment in New Jersey, an employee can't work more than 80% of the hours normally worked in the job. So for example, if the employee normally worked a 40-hour work week, pre-COVID, or really at any time, they would not be able to get benefits if they worked more than 32 hours. So essentially their schedule has to be cut by at least 20%. So that establishes their eligibility. To calculate benefits for partial unemployment and whether or not they will actually collect a partial benefit is going to depend on the earnings from the employer during the work week. So first, you're going to need to figure out what the employee's weekly benefit rate would be if they were on full unemployment. And as I had mentioned, the weekly benefit rate in New Jersey is 60% of the employee's average weekly wage, and it maxes out at $713 a week in 2020. So once you figure out what their weekly benefit rate would be, you can figure out what their partial benefit rate would be. And the partial benefit rate is 120% of the weekly benefit rate minus any earnings from the employer. I'm going to say that again. The partial benefit rate is 120% of the weekly benefit rate minus any earnings from the employer. So now, as I was preparing for today's session, I had a chance to look at the questions that many of you had submitted in advance of today's program. And so many of the questions had to do with partial unemployment. So, that's why I included this in here. And I thought it would be helpful, as much as I hate math, I thought it would be helpful to take you through a quick example of how the math would work out. So if we could go to the next slide, please. Okay, so this is a little tedious, so I just ask you to kind of bear with me. I mean, you have the slide there for reference, but I do want to just kind of take you through it a little bit. So we're going to say that you have an employee who earns $20 an hour, and pre-COVID, they were working a 40-hour work week. So their weekly gross was $800 a week in earnings from the employer. Their weekly benefit rate, if they were collecting full unemployment, would have been $480, right? That's 60% of their gross of $800. For their partial benefit rate calculation, you multiply the weekly benefit rate, the 480 in this case, by 120%, which gives us $576. So this employee, given these facts and circumstances, would be eligible for a partial benefit in any week in which they did not earn $576 from their employer. So I've given you two scenarios here. So in scenario A, using the facts laid out in the example above, we're going to say that the employee worked 4 days and they worked 8 hours per day. So that is a 20% cut in their normal hours. So that's going to establish their eligibility. But now you need to determine if they will qualify for benefits based on those earnings. $20 per hour times 32 hours is $640 that the employer will be paying them in earnings for the week. This is more than the partial benefit rate of $576. So that employee should not be eligible for a partial benefit that week as laid out in this scenario. In scenario B, the employee works 2 days for 8 hours per day, so for a total of 16 hours in the work week. Again, $20 an hour the employer will be paying them $320 in earnings. This is less than their $576 partial benefit rate, so they should be eligible for a partial benefit minus the earnings from the employer. So $576 minus the $320 earnings from the company means that they would be entitled to $256 in partial benefits. Plus, don't forget the extra $600. So that extra $600, as I had mentioned, is available to anyone determined to be eligible for unemployment. And again, that goes on through the end of July. So, and it will be the case even if they're collecting the partial benefit. So in scenario B, the Division of Unemployment will end up paying $856 to that employee, or claimant, I should say. You know, I mentioned earlier, unemployment really is between the claimant and the state. You don't actually have to go through any of this math, right? The state does that work. But I know that you're curious, and I know that many of you are looking out for your employees, and you want to make sure that if you're cutting their hours, they're going to be able to collect something, right? So this is just really for your reference. As an owner or an HR practitioner, I would never make promises to employees as to what they will collect from unemployment. Again, the Division of Unemployment will make that determination. But this just gives you a sense of what an employee might be entitled to based on their wages and based on the hours that they'll be working for you in any given week. Okay, next slide, please. So as you begin to recall your workers, you may have workers who tell you they don't want to come back. One, they're making more money on unemployment than if they were to come back. Or it could be that they're afraid to return to work. I read yesterday in a Law 360 article that $600 enhancement allows 5 out of every 6 unemployment recipients to make more money out of work than at work. Now, that's a nationwide statistic, but certainly a consideration for employers who are trying to, bring people back to work. And at EANJ, we conducted a pulse survey of our members in late May, and we asked various questions regarding return to work issues. And as you can see on the slide, 6% of the employer respondents at that time indicated that they're already having a hard time getting employees to return to work because they would prefer to collect unemployment. However, and I think so many of the questions that I saw come through, what I'm about to say is going to answer so many of them. If the employer makes an offer to return and the employee refuses, the New Jersey Division of Unemployment requires that the employer notify the division within 48 hours of the employee's failure to return to work. The reality and the purpose of unemployment and that extra $600 is to help workers when there was no work available. Now you're making an offer of employment. Their job is there for them, and the expectation is that they are going to return. If they refuse that, as an employer, your obligation is to notify the division by returning Form BC6, which is the Notice of Failure to apply for or accept suitable work. And if you can move to the next slide, I want to give you a screenshot of where you can find that form. So if you go to the New Jersey Unemployment homepage, which is myunemployment.nj.gov, I have it up on the top of the slide for you. You'll see from there the Tools for Employers section. I circled it in red. When you click on that, the first drop down is going to be Forms and Publication. That is going to bring you to the page that I have here, and you can see there's tabs near the bottom of the screen, what employers can download and print, and the BC6 is the first form that's listed here. Next slide, please. And this is a snapshot of what the BC6 looks like, sort of on the top left of your screen. It's very basic, it's very straightforward. This is what you would fill out and return to the department. And you can see it gives you various spaces for you to fill in and communicate to the department what the situation is. And then there's another form that I want you to be aware of, the B187Q. I don't have a screenshot of that one. Rather, this is just sort of a description of what that form is that the division has up on their website. But the B187Q comes to you quarterly from the department, and it tells you the benefits that are being charged to your account each quarter. You want to check each item on that against your records. You know, if there's someone that's on there that's collecting that shouldn't be, or someone who you offer to return to work who refused that, you want to contest that and fill out the employer section and return it to the department so that they can investigate further. Next slide, please. So unless the employee is indicating that they have a reason, a valid reason for continuing to need to be out, such as childcare or disability, if an offer is made, they should be returning to work. If they don't have a valid reason, the company could choose to view that as a voluntary resignation. Again, work is available to them. Fear is not a valid reason for collecting unemployment. But with that being said, fear is a very real thing. Employees may have a subjective fear of coming back into the workplace. You know, it's going to be important to be attuned to the psychology of the workforce, you know, the morale of those coming back into work. And I think communication is really going to be key here. You know, I spoke about the unemployment compensation dilemma. It's very easy for a business to say, look, it's my way or the highway, you know, come back to work, your job is here for you. And if you don't, well, you know, see ya and good luck to you. But the reality is that staffing is going to be a very big concern. You have people that are skilled and trained, they have a knowledge base, they have relationships with the children and the families that you serve. And it could be very tough to lose them in many circumstances. So I think here you need to make sure that you're thinking like an employer, not just as a business. And it becomes the employer's job to show that worker safety is a top priority. Communicate to your staff that you've established safety precautions and protocols. Let them know the specifics of what you're doing: masks, social distancing, hand washing, more frequent cleanings, you know, whatever it is that you've put into place, you know, and try to deal with that fear through transparency and ongoing communication and maybe some persuasion. Next slide. And I hope I'm doing okay on time here. I'll be wrapping up shortly. But I do want to mention that you need to think about your contingency plans, because how are you going to continue to operate if absenteeism spikes once your staff does return? Because you're going to be telling employees, if you are sick, don't come in. If you've been exposed to someone who is sick, don't come in. This is just our new reality. So part of your planning, you know, you want to plan long-term for these types of absences that you may not have experienced in the past, because, you know, pre-COVID, people came to work sick. That was just the reality for many workplaces. And I don't think that you can really do that anymore. I'm certain that you should not be doing that anymore. So there's sort of this necessary mentality shift, because we can't, on the one hand, tell employees not to come in to work when they're sick, but then on the other hand, you know, hold it against them when they don't come in. So we need to consider how we can be flexible, how we can respond. You know, can we cross-train employees to perform essential functions? Do we have substitutes available to come in when an employee calls out? Or maybe we have an arrangement with a temp agency. You know, I don't know, you guys are an incredible group here on the line today. I'm sure that you can brainstorm ideas which are relative to your industry on, you know, how you can try and overcome some of these staffing issues. Next slide, please. And EANJ has put together a model COVID policy. You can access this even as a non-member through our Return to Work resource page, which can be found at EANJ.org. We've made these resources available to the public. So even as a non-member, you can head over there and access this. Having a policy is going to go a long way in your communication efforts with your employees. But it also directs them in writing to stay home when they're sick, to follow your call-out procedures, to put you on notice if they're experiencing symptoms, and to report to you if they come into contact with someone who is infected. I think this also goes a long way in helping to limit your liability. So it's definitely a good thing. Again, up on our resource page, along with checklists for reopening businesses, an employee screening form, an employee safety pledge. One of the questions that frequently comes up is whether or not we can require employees to get a COVID test before returning to work. The Americans with Disabilities Act is a law that applies to most employers. The employer threshold is 15 or more employees. And it requires that any mandatory medical tests of employees be job-related and consistent with business necessity. Applying this standard to the current COVID pandemic, employers may take steps to determine if employees entering the workforce have COVID-19, because an individual with the virus would pose a direct threat to the health of others. So in general, testing is going to be fine. However, I think that there's practical issues that you want to consider here as well. Because let's say before you reopen, you require that all of your employees coming back be tested, and they're all negative, so you allow them to return to work. But what peace of mind do you have when they come back into work after the weekend, for example, that they didn't become infected? Were they social distancing all weekend? Or did they head down to that house party at the Jersey Shore this past weekend that made headlines on Monday? Governor of Pennsylvania saying, don't go to the Jersey Shore. Were they food shopping without a mask, and did they become exposed? Are they living with someone who became exposed? A negative test today is great for today, but it doesn't necessarily mean anything for the future, right? Because someone could become infected at any time. The other thing to think about here is if you are going to mandate testing, there are wage and hour concerns. If the company is mandating it, it's something that they would have to pay for the employee's time. So one thought that we have in dealing with this is the employee safety pledge that I had mentioned, and we have it up on the screen. This is where the employee pledges to the employer that they're going to do their part. They're committed to safety as well. It's really more psychological, I think, than anything else, not really enforceable necessarily. But interestingly, be on the lookout for a similar pledge from the state of New Jersey. My understanding is that New Jersey will be publishing pledges for both employer-employee, but also for businesses to customers and consumers and clients. So look for that over the next few weeks. I think that we should be seeing that any day. Next slide, please. And this is just really a screenshot for you of our Return to Work resource page. This is what you can look for when you head to our home page. There's so much information that's up here and available to you, and we continue to add to this every day. So it's constantly being updated. We have done EANJ has done a number of webinars over the past few weeks, I should say. Maybe we've done 6 over the past 2 months. And we've made them available to you. So if you want more details on the FFCRA and the New Jersey Family Leave expansion, you can listen to my 1-hour webinar, which is posted up there and available to you on demand at no cost. So that's what I have prepared for you today. I know that there's probably a ton of questions. I'm not sure how we are on time. I did kind of talk a little long, but I will throw it back, I guess, to you, Beverly.